You won't believe the chaos that went down in this courtroom. Rosalind Keenan, a self-proclaimed sovereign citizen, was facing serious charges, resisting and obstructing a police officer, a felony, and driving with a suspended license. But instead of handling things like any normal defendant, she decides to challenge the entire court. She declares herself a free woman on the land, insists on being called by a very specific name, and claims she is only appearing under fraud, menace, and duress. The judge tries to stay patient, but her constant interruptions and bizarre arguments push him closer and closer to the edge. She refuses a lenient plea deal from the prosecutor, claims she doesn't understand the nature of the charges, and starts arguing about legal concepts and her identity like it's some kind of secret code. Tensions rise, warnings are ignored, and the courtroom drama reaches a breaking point. Finally, after repeated interruptions and defiance, the judge finds her in contempt of court and orders her jailed for 24 hours. This is one of those courtroom moments that will leave you shaking your head, full of frustration, unbelievable claims, and real consequences. If you thought you'd seen strange legal drama before, this one takes it to a whole new level.
Resisting obstructing is a felony now. It's punishable by up to 2 years imprisonment. And driving suspended as a traffic matter, punishable by up to 93 days in jail and a fine of up to $500. Carries 2 points on your driving record and requires that your license be suspended. Someone who is identified as Rosalind Keenan is present, and she wanted to explain more about that. We'll give her a chance to do that, but prosecuting attorney David Marvin is here, and he's representing the state. So let me ask you again, are you Rosalind Ray Keenan?
I'm here as sui juris and propria persona, Rosalind Ray family of Keenan, beneficiary. Is this on record?
Yes, everything has to be on the record, so it's all being recorded.
Okay, I'm here on the special appearance, and I'm a free woman on the land. I'm here under fraud, menace, and duress. I am the private woman, Rosalind-Ray :
All right.
Keenan. The all capital mentioned name is the only appellation given to me. Anytime I autograph is to be done in a certain manner that I have here, or it's forgery. Could you do this to the judge, please? That's mine. Thank you.
All right, I'll accept this.
Thank you.
All right, so I think we have the right person here. When she signed her bond, she signed it as Rosalind Ray Keenan, beneficiary, with quick bail bonds. All right, now we've got another issue. This is a felony charge. The first one is. The second one is under the Motor Vehicle Code. And it requires that we have a preliminary examination, or it requires that you're entitled to a preliminary examination. We had a pre-exam conference last week, and you expressed at that time that you did not wish to have an attorney. You're here with you this morning without an attorney, and we'll address that in a moment. You've been talking with Mr. Marvin. You have an absolute right to represent yourself. I normally don't recommend it. Mr. Marvin, is there a plea offer here?
There is, and I'll tell you about that. But I wanted to mention that this is, I believe, the third time we've sat down, and so this is dragged out a bit, but only because she's not represented, and in these 3 separate meetings and adjournments, the court has allowed those, and I appreciate it. I have spent a lot of time with her and her son, who's here. He's always been here, and they're very honest and they're good intended.
Thank you.
And I think that we've come to a resolution that I believe is fair. I've offered, I'm going to state it for the record, and only time will tell if she's going to accept it, in hopefully 2 seconds. But what I would do is offer an attempt resisting and obstructing and dismiss count 2. And I would ask that the court set this for sentencing at a later date, and I'd ask for 6 months. And if by that time there's no other incidents with law enforcement or any other reason to continue, I would dismiss this, or at any time before that if I felt that it was necessary. And again, after working with her, I don't think this is the kind of thing that should be, I would hate to see this upstairs as her first felony. I think that she's interested in a way of life that she's honestly trying to understand, but I think that partly to assist her, I've kind of hatched this plan, and I've offered that. I have the feeling she's going to take it today, but if not, I've got my officer and we're ready for a pre-law.
Driving suspended charge. And he is offering to dismiss the felony charge and reduce it to a charge called attempted resisting obstructing a police officer. That's a misdemeanor. It's punishable by up to a year in jail and a fine of up to $1,000. Do you understand that charge?
No, I don't understand the nature and the cause of the
All right,
charges.
Mr. Marvin, let's just do a prelim. I'm not gonna tap dance with her. You may be more sympathetic about this flat earth nonsense than I am. But if I'm gonna have to argue about everything from who she is to what the charge is, it'd be easier to just put on the prelim. From the affidavit of probable cause, her conduct was outrageous with a capital O. And so I'll give you one more opportunity, Ms. Keenan. Mr. Marvin is agreeing to dismiss the driving suspended charge. The record shows your license is suspended from Indiana and you don't have a valid Michigan license. That's a benefit. It won't affect your driving privileges.
Excuse me? What'd you say about the,
It's a benefit. And
no, before that about the license?
he's dismissing it. And it won't affect your driving privileges here or Michigan or Indiana if he dismisses that. So he's offering to dismiss it. And that's a benefit. He is offering to reduce the felony charge to a misdemeanor. And that's attempted resisting and obstructing a police officer. If you wish to do that, we can pursue it now. If you don't, we can take testimony. The officer's been waiting here for 3 hours. What would you like to do?
Are you asking me to take a plea?
I'm asking you if you're willing to accept the prosecutor's plea offer.
Well, I don't understand that.
Mr. Marvin, let's
Explain
just
it.
put
I'm
on
not
a
playing
prelim.
games. I'm serious.
You are playing games. And first of all, you
I'm trying
don't.
to advance to
All right,
what I'm
stop.
here.
You don't interrupt the judge, whether you're a flat earther or
I'm
not.
not flat earth. So
All right, well, this crazy stuff you're saying, I've got very little patience for it. You don't have an attorney, which concerns me, because these charges could result in your incarceration. I will appoint an attorney for you. All you got to do is tell me. But you also have the absolute right to represent yourself. So do you wish to represent yourself, or would you like me to get an attorney to assist you with
it's
this?
my right to appear for myself.
It is.
I don't think it would be a violation of your oath of office
To do what?
to if you did your duty under the Constitution, because I'm seeking legal intent, not advice.
Well, do you
And
want me to appoint an attorney for you, or would you like to represent yourself?
So may I ask, what jurisdiction? Is this civil or criminal?
This is a criminal case, which points out the fact that you could use a lawyer if you can't tell the difference between a civil and a criminal case. Criminal case means you could go to jail, in this case, for up to 2 years. In a civil case, there's no possibility of jail. It's usually over money damages or other types of non-jail relief, like other types of non-jail relief. So yes, this is a criminal case.
Well, thank you. So, you said the record is on.
Yes.
Could the record of the court show that this is a criminal action? And my next question is, I know that the Constitution grants the court 2 types of criminal jurisdictions. One is criminal jurisdiction under common law, and the other is criminal jurisdiction under admiralty or military tribunal venue under Article 1, Section 8, Clause 17 of the Constitution. Under which of these 2 jurisdictions is the court intending to try me?
This is statutory jurisdiction of the law of the state of Michigan. It's not any of those things, including the wacky admiralty.
You are about to witness one of the most chaotic courtroom moments you'll ever see. Rosalind Keenan, a self-proclaimed sovereign citizen, faced serious charges, resisting and obstructing a police officer, a felony, and driving with a suspended license, a misdemeanor. On paper, it seems like a straightforward case, something that could be resolved quickly. But from the moment she enters the courtroom, it becomes clear this is going to be anything but ordinary. From the start, Ms. Keenan makes it obvious that she does not intend to follow the rules of the courtroom. She introduces herself not as a defendant, but in the elaborate style of a sovereign citizen, insisting on being called Rosalind Ray Keenan, beneficiary. She claims she is a free woman on the land, and repeatedly insists that she is only appearing under fraud, menace, and duress. She wants everyone to use her name in a specific way and even demands that any signatures or documents reflect her unique titles. These declarations immediately set the tone. This is going to be a hearing dominated by argument, interruption, and what the judge soon refers to as nonsense. The judge remains calm and professional, but the tension in the room is palpable. He carefully explains the charges and allows the prosecutor to offer a very lenient plea deal. The deal would reduce the felony resisting and obstructing charge to a misdemeanor, attempted offense, and dismiss the suspended license charge entirely. All Ms. Keenan had to do was stay out of trouble for 6 months. On the surface, it was a simple opportunity to resolve the matter. But she refuses. She repeatedly claims she does not understand the nature and the cause of the charge, and challenges the court's authority at every turn. Every explanation from the judge is met with questions, interruptions, and long-winded arguments about legal theory, identity, and her rights. She insists on debating her name, her status as a free woman on the land, and the legitimacy of the entire legal system. She refuses to acknowledge even the most basic aspects of the charges against her, which only escalates the frustration in the courtroom. As time passes, the courtroom becomes a battle of patience versus defiance. The judge tries to maintain order, giving her multiple warnings, but Ms. Keenan continues to speak over him, argue about jurisdiction, and make claims that have nothing to do with the actual case. She questions the very foundation of the court, insists on her legal peculiarities, and treats the proceedings as though they were some kind of abstract debate rather than real criminal charges. The prosecutor, trying to navigate this surreal situation, presents the plea deal again, emphasizing how easy it would be for her to resolve the case without further trouble. Yet Ms. Keenan refuses once more, insisting on her convoluted interpretation of the law. She repeatedly interrupts, making it clear she is determined to challenge the system, no matter how simple the resolution. The judge's patience begins to wear thin. He warns her firmly that if she continues to interrupt and argue about identity and jurisdiction, he will hold her in contempt of court. He explains that the legal process is not optional, that her defiance is wasting the court's time, and that continued disruption will have serious consequences. Despite these warnings, she continues her arguments, speaking over the judge, questioning every statement, and refusing to comply with standard courtroom procedure. At times, the courtroom almost feels frozen in disbelief. The audience, the prosecutor, and even the judge are forced to witness a surreal display of legal defiance. Her arguments have little to do with the charges she faces and everything to do with asserting her personal worldview. She speaks in ways that confuse, frustrate, and delay the proceedings, turning what could have been a short hearing into a drawn-out spectacle. As the hours drag on, the tension becomes unbearable. The judge repeats his warnings, the prosecutor reiterates the plea deal, and ends. Keenan continues to argue, defy, and interrupt. Her insistence on her titles, her sovereignty, and her legal interpretations creates a chaotic environment that tests the patience of everyone present. The courtroom drama is intense, a mix of frustration, disbelief, and fascination. Finally, after repeated warnings and continued interruptions, the judge reaches his limit. He finds Ms. Keenan in contempt of court. He orders her to be jailed for 24 hours, and the courtroom reacts to the culmination of hours of disruption. This is the reality check that the court had warned about, a tangible consequence for her repeated defiance and refusal to engage with the legal process. Throughout the hearing, the narrator can't help but comment on the absurdity of the situation. Sovereign citizens like Ms. Keenan often waste enormous amounts of court time with what he calls fake legal nonsense. While their arguments may sound clever or confusing, they carry very real consequences. The judge's decision to hold her in contempt is more than just punishment. It's a demonstration of the court asserting authority and enforcing order in the face of defiance. The case also serves as a cautionary tale. Legal systems are not optional, and refusing a reasonable plea or refusing to acknowledge the law can quickly escalate into far more serious consequences. What started as a relatively minor set of charges became a drawn-out legal battle simply because one individual refused to play by the rules. The courtroom drama, the arguments, and the eventual contempt ruling all highlight the clash between fringe beliefs and real-world legal consequences. In the end, this is more than just a bizarre courtroom episode, it's a glimpse into the tension that arises when personal ideology collides with established law. Ms. Keenan's insistence on sovereignty, her elaborate legal titles, and her refusal to acknowledge the charges exemplify the challenges judges face when individuals attempt to manipulate or reject the system entirely. For viewer, this hearing is both shocking and oddly fascinating. The frustration, the absurdity, the legal gymnastics, it all makes for one of the most memorable courtroom encounters in recent times. It's a reminder that, while courtroom dramas are often scripted for television, real-life events can be just as chaotic, if not more. And in this case, reality caught up with Ms. Keenan in the form of a contempt ruling, a clear statement from the court that legal nonsense has limits, and that defiance has consequences. This courtroom exchange will be remembered for the clash of patience versus defiance, law versus ideology, and reason versus disruption. It's a masterclass in what happens when someone refuses to follow the law and the consequences that inevitably follow, no matter how convincing their arguments might sound.
This is criminal jurisdiction authorized by the state legislature here in the state of Michigan.
Thank you. Well, please let the record of the court show that the court intends to conduct a criminal action against me under statutory jurisdiction. But that makes me wonder, I have never heard of criminal action under statutory jurisdiction, and there is no such jurisdiction established in the Constitution, and I will be able to proceed if you can show me where I can find the published rules of civil procedures under a statutory jurisdiction and where this nature, cause, and jurisdiction exists. It is crucial that I have the published rules of procedure so that I can conduct a fair defense and fair trial. Otherwise, this needs to be dismissed, and I would like it in writing, please.
Thank you. It's not civil procedure, it's criminal procedure, and the defendant doesn't come up and show, court, tell me why I get to do this. You've been charged under the criminal statutes of the state of Michigan, and I've just advised you of that on the record. I'm just trying to establish at this point whether you want to represent yourself or not. As I mentioned, the conduct in here in the affidavit or the bond information report is outrageous with a capital O. And you could very well go to jail for a substantial period of time. Mr. Marvin was trying to extend to you an opportunity to avoid that option, but you're wasting all of our time with this stuff that doesn't have any legal merit. I'm offering to give you an attorney who can actually argue any legal merit or advise you or assist you in this regard. But we've had some White Pigeon police officers here on overtime for several hours. They're still waiting for you to decide what you wish to do. I haven't even gone over the first. Well, first of all, we had to establish who you were. That took much more time than it deserved. Secondly, I'm trying to determine whether you wish to have an attorney or not. Again, you do have the right to represent yourself. You wish to, but you've exhibited to me that you don't understand the law, and you're at risk of being incarcerated for this conduct. So to further comment on Mr. Marvin's offer, if you pled to the charge of attempted resisting and obstructing a police officer, he offered to defer the sentence for 6 months, and if there were no further problems, to dismiss it, which is very generous based on the police report bond information that I came with the file. So what would you like to do here today? Do you wish to represent yourself?
Thank you. I do. I know I can peer for myself. I'm competent and I am confident. Okay?
All right.
So
the next question is, are you willing to accept Mr. Marvin's plea offer to plead to the misdemeanor charge?
I wasn't completed with what I wanted to say to you, please.
Okay.
May I? Thank you. So I wanted to say that I don't believe it's a violation of your oath of office if you did your duty under the Constitution, because I'm seeking legal intent. Okay, so I have the right to peer for myself. In order to intelligently defend myself, I have to know the jurisdiction this court is operating under, because the rules of civil procedure under common law jurisdiction are very different from the rules of civil procedure
under
admiralty or military tribunal venue.
Stop. You went through this before.
I know.
This is not civil procedure.
The Sixth Amendment grants me the right to know the jurisdiction being applied.
And I told you what it was.
And it gives you the duty.
All right, stop. If you interrupt me one more time, I'm going to find you in contempt and you're going to go to jail.
Objection, please.
All right, please.
Please.
We're going to talk about this tomorrow at 3 o'clock. I find that you're in contempt. You're going to jail right now, and we will. Well, you have been.
I'm simply
this matter
trying
is
to
adjourned until
exercise
tomorrow
my
at
Sixth
3
Amendment
o'clock.
rights, please.
Well, you can think about
And
it
we can go
overnight in
forward
jail.
with this right now, please.
No, you're going to
I do
jail
not
for
wish to be in
24 hours.
contempt.
I know you don't wish to go to jail, but you certainly
I
have
will
earned it.
continue with this if you'll please let me finish.
We'll talk about it tomorrow at 3 o'clock. and you will be more respectful to the court.
I
You
can
will speak-
provide the
You will not interrupt the
citations.
court. Your citations are meaningless.
I'm sorry I
So you
interrupted
can
you. Do you
go
wanna
with the
continue?
officer. I don't want to argue about it. Take
I'm
her
not
out of here. We
arguing.
will address this tomorrow at 3:00.
Yeah, I don't know what's going on, and I don't think this was a fair trial.
We haven't had a trial yet.
A fair